Welcome to our Breaking Ground series today. Sophie, Dan and I will be talking through some key changes to the Building Safety Act. Before we get going, just to say, we've got some housekeeping, which I'm sure a lot of you will be aware of if you've been on one of our Breaking Ground sessions before. But the session is being recorded and it will be available to view later. And of course, if you have any questions, please pop them in the Q&A box and we'll try to address as many of them as we can in the time available. If not, we'll try to contact you after. We do have some feedback that we send to you afterwards. Please do fill it in. It's really valuable to us to know, firstly, how we're doing, but also any other subject matter that you might be interested to hear from us. So the Building Safety Act. Today's edition of our Breaking Ground talks about the Building Safety Act. It's the first in a two-part series, and what we're looking at for these purposes is the issues it raises, which are potentially relevant from a professional indemnity context, both for the insurers on the call, but also insureds, so contractors, architects, engineers, and other consultants. Now, the Act has been brought into force as part of a fundamental reform of building safety system. The objectives of the Act are for lessons to be learned following the tragic events of the Grenfell Tower fire, and with a view to remedying what have been identified as systemic issues by Dame Judith Hackett in her inquiry, with the overall intention of strengthening the regulatory system. Now, there is an awful lot to consider here because the Act introduces an awful lot of legislative changes, and many of those are not going to be relevant to the insurance angle that we're covering today. The Act itself runs to something like 230 pages. We're not going to be able to cover 230 pages worth of legislation in 20 minutes. What Sophie, Dan and I are going to focus on are firstly limitation periods for certain types of claims, largely focused on the Defective Premises Act. I'll talk with Sophie about that. And then I'm going to talk to Dan about the introduction of a new remedy called a building liability order. Then on the 6th of October, Andrea Lynch is going to be the quiz master, and she'll be asking questions of our colleagues David Phillips and Adrian Quintner as a follow-on to this. So they're going to focus on the implications of this Act for professional indemnity policies, and also they will delve a bit deeper into the Defective Premises Act that Sophie will touch on today. Just before I start asking the questions and I sort of hand the baton over, it's important to say that this is brand new legislation. It's coming this year, it's coming to force over a period of time, so certain things are coming in as time passes. But also the government's guidance on the Act has been in something of a state of flux. An original guidance fact sheet was issued and then withdrawn. It was then replaced by a shorter note on the 25th of July 2022. That short note has since been withdrawn and it's been replaced by a longer explanatory note. So we're really seeing changes happening rapidly, and I suspect further changes are going to be forthcoming. So please do keep an eye for further updates, and we will also. And then finally, there will be a broader view of the Act that I'm undertaking with some colleagues across sector at Mills and Reeve on the 7th of December. That'll be focusing on from the context of the construction, our projects team, real estate and insurance. So a really wide-ranging review on that one, so keep an eye open for invites on that. So I'm going to start by talking to Sophie about changes to the Building Safety Act and specifically about limitation. One of the key changes is an amendment to the limitation date for claims arising from the Defective Premises Act 1972. Sophie, let's just say what the position was beforehand. What was the limitation position on those?
So under Section 1 of the Defective Premises Act 1972, a person who carries out work in connection with the provision of a dwelling owes a duty to ensure that that work is done in a professional and workmanlike manner, and that the resulting building is fit for habitation. And the potential liability arising from that section only applies to work that's been carried out to new buildings. So before the Building Safety Act came into force, any claim made under that section of the Defective Premises Act had to be made within 6 years of the building being completed.
Okay, so fairly standard provision there. What's the position now that the Building Safety Act's come into force?
So now, if a building is completed after the Building Safety Act came into force, which was on the 28th of June this year, then going forward, any person who's entitled to bring a claim under Section 1 of the DPA has 15 years in which to do so. But the Building Safety Act also has a retrospective effect, which means that if a person was already entitled to bring a claim under Section 1 of the DPA at the time the Building Safety Act came into force, so the building was already completed at that date, then the limitation period is 30 years, which means any building that was completed at any time since 1992.
Okay, well, that I'm sure will be shocking some people on this webinar. A lot of my clients will say they only do refurbishment work, they don't start new buildings. DPA doesn't apply to them, or has that changed too?
So the DPA didn't apply to them before the Building Safety Act came into force because the focus was on work that was carried out to the provision of a dwelling. But now Section 134 of the Building Safety Act had added a new section to the Defective Premises Act, Section 2A, which extends the scope of the DPA to include where a person in the course of business takes on work in relation to any part of a building. And that will then include any refurbishment or refitting works.
Okay, so what about the timings for those claims?
So there's no retrospective effect for that part of the Building Safety Act. But as with Section 1 of the Defective Premises Act, if a person's entitled to bring a claim under Section 2A, then they'll now have 15 years in which to do so.
Okay. There's a new section about cladding product. What's the position in relation to those?
So the Building Safety Act introduced a couple of new causes of action in relation to claims arising from the marketing and supply of cladding and construction products. And that's Section 148 and 149 of the Building Safety Act, which allow claims to be brought against a party who either fails to comply with a product requirement in connection with a construction or a cladding product, or markets and supplies a construction or cladding product using a misleading statement, or manufactures a construction or cladding product which is inherently defective, and once that product is incorporated into a building, causes the dwelling to become unfit for habitation.
Okay, so that's an interesting development that might impact on people looking to bring contribution claims as well. What sort of damage is this intended to cover, Sophie?
So these sections allow claims to be brought against manufacturers and product suppliers in respect of personal injury, damage to property, and economic loss for anyone who has an interest in a dwelling and has suffered a loss as a result of it being unfit for habitation. So that might be a leaseholder, but as you say, it might also be a contractor or an architect who wants to pursue a contribution claim against a manufacturer. And for claims arising from construction products, the new limitation period is 15 years from the date that the right of action accrued. So that's when the building was built. But for defective cladding products, there is a retrospective limitation period of 30 years if the right of action accrued before the 28th of June 2022. So again, that's back to 1992. Or if the cause of action accrued after that date, then the limitation period is 15 years.
Okay, as I say, the 30-year limitation period will have some people a bit concerned. It does seem a bit harsh. What's the position if you've already settled a claim or perhaps been to court and had that claim struck out?
So there are a couple of caveats, and one of them is that if a claim that has been made retrospectively has already been settled or received final determination by the courts, so an award's been made or it's already been struck out, then that claim has to be dismissed.
Okay, what about those clients who've dealt with the construction of particularly old buildings dating back to 92? They haven't settled a claim or anything like that. Are there any times when those retrospective limitation periods aren't going to apply?
So the other caveat is that a claim that's made retrospectively must be dismissed if it breaches the defendant's human rights. But we don't really know how that's going to be applied as yet. So hypothetically, we can see that if a defendant has agreed an express term to limit their liability to a certain number of years, and on the back of that contractual arrangement, they've already destroyed their documents. So for data protection reasons, then it seems to us that there might be an argument that a claim would breach the defendant's right to a fair trial. That might also be triggered if the key people involved in the project have died and the defendant has no documents. But we don't really know at the moment, so we'll have to wait and see how the courts interpret this when it comes before the courts.
Okay, and just to look at the other side of the fence, so anyone thinking about pursuing it, what would be the position if a claimant was entitled to bring a claim under the DPA or this new cause of action relating to cladding products, but the Building Safety Act was brought into force, say, a couple of months too late?
So there is a 1-year buffer, which is known as the initial period, for claims that are already almost at the end of the 30-year extended limitation period, and that potentially will give additional time for a claimant.
Okay. In terms of limitation, is there anything else we need to be aware of?
So the Building Safety Act has also introduced a 15-year limitation period for Section 38 of the Building Act 1984. So Section 38 of the Building Act 1984 provides a statutory right to claim compensation for physical damage, so injury or damage to a property, from those responsible if the damage was caused by a breach of the building regulations. So this section of the Building Act was always on the statute books since 1984, but it hadn't previously been brought into force, and the Building Safety Act has changed that. The change only applies going forwards, but unlike the Defective Premises Act, this section will apply to both commercial and domestic properties.
Okay, well, that's the end of our limitation section. So bringing over to Dan now to talk about building liability orders. Dan, this is completely new. In broad terms, what are these?
Yes, so the Building Safety Act introduces a new scheme where liability for construction work can be extended beyond the entity involved in the original build, which may often no longer exist, and that can be extended to associated entities. So associated entities, it can include the parent or the subsidiary of the company in question, even where those companies have had no involvement in the work complained of. So it's a scheme which intentionally pierces the corporate veil.
Okay, Dan, why is this being introduced? What's the intention behind it? What sort of situations is the government looking to address here?
So as you've said, this is brand new legislation. But looking back through some of the parliamentary debates held on the wording of the Building Safety Act, though, we've put an extract from one of these on the slide. These suggest that the building liability orders are aimed at situations where construction projects have been carried out by developers through shell companies or special purpose vehicles, and those have since been solved, therefore removing a potential right of redress for affected people.
Okay, well, parliamentary debates only go so far. Is there any other guidance we can look at to interpret these provisions?
Yes, so again, as you mentioned at the start, there are explanatory notes which have been produced alongside the Building Safety Act. They are limited on the subject of building liability orders, but what we've seen does echo the parliamentary debates, as they suggest this legislation is intended for situations involving wound up special purpose vehicles. But it's quite important to bear in mind that these government explanatory notes, they don't have statutory force. So courts will, or they should, pay little attention to these. They can be created for political publicity as well as informative purposes. But nevertheless, these do give some insight as to the intended purpose of this legislation.
Okay, thank you. So on the screen, we've set out the relevant part from section 130, subsection 2. And the bit I'd just like to focus on now, Dan, is the words underlined, so relevant liability. What counts as a relevant liability?
Yes, so this is certainly going to include the liability under a court judgment, and it's likely to extend to an arbitration award as well. Adjudication decisions might not be sufficient though, because they aren't final determinations and they can only be enforced via court proceedings.
Okay, so moving on to subsection 3, you'll see from the screen there's 2 sections to this. So a relevant liability is incurred under the Defective Premises Act and the Building Act, as we just discussed with Sophie. The rather more broad and generic phrase is the as a result of a building safety risk. Dan, can you talk us through what that would encompass?
Yeah, so it's possible that only part of a judgment could be incurred through a building safety risk, and therefore it could be incorporated into a building liability order. Take, for example, if you've got defects in a building that don't cause a building safety risk, such as the wrong colour of the cladding panels having been installed, or where you've got non-structural damage caused by a flood. The costs for carrying out those parts of the remediation works that arguably not be recoverable and therefore be excluded from a building liability order.
Okay, so we know how the liability arises. Let's move on to how the Act allows the corporate veil to be pierced, as you mentioned earlier. This is dealt with by section 131, and that's on the slide. Dan, it talks about body corporates here. How can a body corporate be connected or associated, which is the word used, with another for the purpose of making a BLO?
So a body corporate is going to be associated with the original party if one controls the other, or there's a third body corporate that controls them both.
Okay, well, I'm hoping everyone's following. We now move from association to control. Can you talk us through control, how that arises?
So we've put the test out in more detail on the slide, but you can see it's quite complicated and it is quite detailed in terms of how you sort of look at this control test. But generally speaking, a company is going to be controlling another if it's entitled to at least half of the shares, the voting rights, or the shareholder income or assets on winding up, or whether that party has the ability to control, either directly or indirectly, the other corporate body as it wishes.
Okay, so there's some really quite complicated corporate issues to be assessed here. So let's move on, because we can only go so far with that bit, and timescales. Sophie's talked about claims potentially dating back to 1992. Obviously, corporate structures develop over time. What if that connection, association, or control no longer exists, or perhaps it's only started more recently, long after the original works were completed?
Yeah, so the relevant period here is going to start when the work commences and it ends when the building liability order is made. So regardless, therefore, of whether an associated company is incorporated sometime after the commencement of these works complained of, it's still going to be an associate for the purposes of a building liability order, due to this period extending until the date a building liability order is made. So Sophie talked earlier about the DPA claims, where this cause of action accrued before 28th of June this year. So a party has 30 years to bring such a claim. In these instances, a company could be associated with another if this association test we've met and we talked about has been sort of reached at any time since 1992. There is a sort of a further right of parties, because we're talking about such a long period of time where a company's links are not quite clear. For example, due to this sort of length of time involved, parties can apply to the High Court for further information about a company's connections.
Okay. And then finally, just before we move to the case study and perhaps put the audience to a bit of work, I just wanted to touch on the existence of discretion for the court. Dan, the slide here says it's taken from section 130, subsection 1, and it says a building liability order can be made if the High Court considers it is just and equitable to do so. Now, appreciate we're in uncharted territory here, but what might be meant by this phrase?
So at the moment, there's no guidance or case law, and there's nothing in the explanatory notes that's available to help us determine what is just and equitable, and therefore how a court might apply this provision when making a building liability order. We can see that some might argue that almost anything could be taken into account by a court in considering what is just and equitable. But the extracts on the parliamentary debates, they suggest that this sort of wording is generally intended to convey responsibility or how blame is going to be apportioned. But, you know, as you can see, this is quite a wide definition, and it's quite clear that without further guidance, it's going to be open to interpretation, therefore challenged by parties and possibly through a test case. So watch this space.
Okay. We thought a bit of a case study and a few questions for you might help bring some of this to life. So just background facts, and then we'll ask a couple of questions. You've got a company called Ace Cladding Limited. I hope no one from Ace Cladding Limited is on here, but we did do our best to be anonymous. It's appointed to design the external facade of a 20-storey residential building. Until 2015, it was a wholly owned subsidiary of Ace Tower Limited. Now, it transpires that the works were in fact not Ace at all, and in 2017, following a routine inspection, it's discovered that there's serious fire compartmentation issues within the building. Fast forward to 2022, and a group of individual leaseholder flat owners in the building try to bring a claim against Ace Cladding. They never had any contractual links, so their remedy is the one that Sophie talked about earlier, the Defective Premises Act, as extended by the Building Safety Act. And what they try to say is that the building is unfit for habitation. They contact Ace Cladding and discover that it's been dissolved. So it's got no money, so it needs to think of another way. First question that hopefully the poll will come up for you now. Do those leaseholders have any potential right of redress against Ace Tower? Simple question, yes or no. To the 93% of you who said yes, well done. There potentially is a route here to pursue a BLO against Ace Tower, but there are various hurdles to overcome. So they've got to get through those tests that Dan talked about. It does look like Ace Tower and Ace Cladding potentially were associated at the time of construction. It doesn't matter the fact that it is since been unlinked, if you like. But just to note as well, before they can go for the BLO, the leaseholders do face a number of hurdles. They've got to get the relevant liability against Ace Cladding first, so they need a judgment. To get that, they're going to have to prove this building is unfit for habitation. So there are some challenges to overcome. It's not just a straightforward position. So that's poll one. Poll two, this final bit for you. What if the work carried out by Ace Cladding related to refurbishment of the building rather than a new build? Could the building liability order still be sought against Ace Tower? We've got 79% say yes, 21 say no. I think the answer here is no, and the reason it goes back to the discussion we talked about with Sophie earlier. The critical point to being able to get the BLO is the ability to have the relevant liability. The Defective Premises Act has been extended to include refurbishment works, but the wide-ranging changes to limitation periods aren't retrospective. So the leaseholders aren't going to be able to get that relevant liability to act as their basis for the BLO. So the answer to that one is unfortunately no. So just to conclude, I'll wrap this up. It really isn't an understatement to say this is radical and wide-ranging legislation. It's been introduced in the context of cladding and fire safety risks post-Grenfell, but it's not limited to claims relating to cladding. It's building safety, etc. Retrospective changes to the Limitation Act to 30 years is extraordinary and it's unprecedented. And the corporate veil concept, which has existed for more than a century and is the reason why we have limited companies, has meant that it's really very, very difficult for claimants to pierce the corporate veil, and in really only very limited circumstances. So the introduction of a statutory mechanism to allow that to happen is really quite revolutionary. If it sounds like we're conveying doom and gloom, it is also worth thinking about the fact that it isn't just an impact for defences. For those higher up the contractual chain and insurers, potentially this offers opportunities to seek recoveries which either didn't previously exist or perhaps were viewed to be too much of a challenge. But just to conclude, this is new, untested legislation. I'm pretty sure we will see test cases coming through. So this genuinely is one of those talks where it is appropriate to say, watch this space. Many thanks to Sophie and Dan for the work they've done to really be able to explain this and enlighten us about this statute. Please do remember about Andrea, David and Adrian's talk on the 6th of October, where we'll do a bit more consideration of these issues. I'm pleased to say actually we've had no questions, so we've either you haven't got any or we've answered them all as we've gone along. And then finally, just before we sign off, as I say, feedback really important. If you do have any topics you would like us to talk about, please pop them in the feedback and we'll do our best to cover them. But thank you very much for attending, and enjoy the rest of your day.